Hello, everybody. Thank you for joining my session, Creativity and Copyrights. Thank you, Tala, and thank you, Creative View Arts, for the opportunity to present to you all today. So today we will be talking about creativity and copyright, specifically in the world of sampling. Okay. If you have any questions, please feel free to leave them in the chat box. We'll be monitoring the chat box for questions, and we'll do a Q&A afterwards. But of course, so you don't forget your question, feel free to leave it in the chat box, and we'll kick off our Q&A with the questions that present in the chat box. Okay. So let's get this presentation started. I want to share my screen with you all here. It's the entire screen. Give me 2 seconds here, guys. All right. Here we go. So, welcome to Creativity versus Copyright in the World of Sampling. Today, I'm going to walk you all through the types of copyrights because that's important so we know when we're talking about sampling where they come from, the importance of your copyright registration, what sampling is by definition, how sampling can go just so left and so wrong, the things that the court considers when we talk about what sampling is and how a court determines whether sampling is actually the sampling that has occurred, whether it's actually infringement or not. And then, of course, we'll talk about some case studies that are popular in the courts with some of your favorite celebrities, followed by some proper sampling tips so you know moving forward how to avoid the pitfalls that some of your favorite celebrities have fell victim to when you want to sample a song. And then finally, we'll do our Q&A. So let's get moving here. So first, we have the various types of copyrights. This is so critical because you have to understand where your rights come from in order to be able to assert them, okay? So a song has 2 types of copyrights. We have the musical composition copyright, which is AKA, I call it the song. And then we also have the sound recording copyright, AKA the master recording. Now, on the song side here, a song or a musical composition is protecting the words and the music or the lyrics and what most of you all are familiar with, the beat, okay? Now, of that protection, once you create the song, it belongs to you and you own the copyrights to that. Now, the benefit of copywriting your song, one of the benefits, we'll talk about some more later, but one of the benefits is that you then get to participate in all of these bundle of rights. These bundle of rights, particularly, you have the right to reproduce your song. You have the right to distribute your song. You have the right to prepare derivative works based on your song. You have the right to perform your song and the right to display your song. Now, you have these rights, but you also have the right to give somebody else permission to do all of these things, okay? Now, specifically for the purpose of our conversation, the one I have bolded here, the right to prepare derivative works based on your work, that is the sampling right. That is the right that everyone is litigating, okay? So part of this exclusive bundle of rights for a copyright owner, this is the right that they have, that the person who allegedly has violated them, this is the right that they have violated, the right to prepare a derivative work, because they are the only person that can prepare a derivative work, i.e. a sample based on their own work, or give permission for somebody else to do that, okay? So now, moving down, we have the performing arts copyright. The song is a performing arts copyright, and I use this so you all know which form, if you're going to copyright your own song, you want to use. You want to use the PA form, which is a performing arts copyright. And this copyright, as many of you all know, is owned by the songwriter and or the publisher. So this is the publishing copyright. When you hear people talk about, owning their publishing and things of that nature, this is the copyright specifically that they are talking about in the song. The copyright that is particular to the words in the music, okay? Now, moving over to our master copyright. in your master copyright, the master copyright simply protects the vocal performance. When we say vocal performance, of course, you have the words and the music that are included in that, but this is particular to the vocal performance, the style of the song, the way the person has delivered the lyrics. This is the same reason why you can have several different versions, different masters of the same song, because you have the song itself, but you may have several different performers or artists that have performed that same song. So while the songwriters may own the underlying position and own the song, several different performers or artists have performed that song, and they own the actual recording of their particular version of that song. Okay. Now, like the song, you have a bundle of rights that comes along with copyright registration. And I want to stress copyright registration because this exclusive bundle of rights, although your copyright vests with you as soon as you create it, so there is not a hard and fast rule that you have to copyright it. You want to copyright it because with that copyright comes a bundle of rights and a whole lot of other stuff that you get through the government by copywriting your song through copyright.gov. Okay. So just like the song, you have the right to reproduce, the right to prepare derivative work, the right to distribute, and the right to perform. Again, this is your copyright or your particular right in this matter that is related to sampling. This is the right that somebody violates if they sample your vocal performance in their work, okay? The form you want to use for the copyright of a master recording is the SR form, which is a sound recording form. And who owns this? The label or the artist owns this particular copyright. So typically the artist will own it and they may transfer ownership over to the record label or the artist themselves. As you hear people say, I've licensed my masters to the record company, because the artist owns that master, but they've licensed it over to the company. Okay. So these are your two copyrights in one particular song. And that's important because the use of any of these rights without permission is basic copyright infringement. And that's why it's important to understand that you have two copyrights, and the use in violation of any of these rights equals copyright infringement. Now, for our particular purposes, as I said, the derivative works is the one that is violated if somebody samples your work without permission. Okay. Now, moving on here. So let's talk about the importance of copyright registration. The importance of copyright registration, first, is you are then allowed to collect 100% of your royalties. Why is collection of 100% of your royalties so important, Stephanie? Well, it is so important because, as you all, I'm sure, know, most recently the law passed the Mechanical Licensing Collective. The collective is in charge of tracking down songwriters and making sure they're paid their copyright. The problem had become where, because individuals were not copyrighting their music, the digital service providers like your Apples and your Spotifys were unable to identify who the music belonged to or the songs belonged to and pay them their mechanical royalties. So they would just be sitting on all of these royalties, okay? So with the Mechanical Licensing Collective, they're here to help start paying out all of these songwriters who have failed technically to copyright their music. So you want to copyright your music because, let's just say, for instance, somebody doesn't want to enter into a contract. By law, they can use your music by following a formula that's in our copyright law and just paying you out. But they have to be able to find you. If they can't find you, they can't pay you. So you're missing out on royalties if you do not register your copyright. And the royalty you're missing out on specifically is your mechanical royalty. So you want to copyright your music, so you're collecting 100% of your royalties, not just a portion of them. Most people focus on making sure that they're registered for ASCAP or BMI because they want to make sure they collect that performance royalty check. That check is definitely important, but what you're also missing out on is the mechanical royalties. You want to collect all of your bag, not just some of it, all of it, right? So register your copyright. Next, we have delays in filing an infringement or sampling lawsuit. So let's just say somebody infringes or samples your song without your permission. Well, now, according to the copyright law, not only do you have to have your song registered with the Copyright Office, you have to have a registration certificate in hand, meaning you can't, a week before you want to file your lawsuit, go ahead and go on copyright.gov and register your song. doesn't work like that anymore. You actually have to have registered the song and wait for the Copyright Office to send you your certificate back in order for you to file that lawsuit. Well, guess what, guys? It's not a quick process. As we all know, the government does not work fast. So copyright registrations, I filed registrations in February, and I may not hear anything back from the Copyright Office until October. So just giving you an idea of how long it takes for you to get a copyright certificate in hand, you want to go ahead and file your copyright registration when there's no problem, because then you're not pressed to get the certificate back. And if you need it, you already have it, because you can't even file your lawsuit now without the certificate in hand, which is a big deal, right? So don't delay in getting that copyright registration file, because if somebody samples your music without permission, you want to have that in hand to go ahead and say, okay, no, here's my certificate. Let's go ahead and file this lawsuit today. Not, oh, let's wait 6 to 8 months because now I have to wait for the copyright to go through and for it to process before we can file a lawsuit. Not fun at all. So next, we have that the law presumes that your registration is valid if you go ahead and immediately copyright your music once it's out for the world to hear. And I say once it's out for the world to hear, once it's commercially available for the world, you want to go ahead and copyright and register it with the Copyright Office. And I say commercially available also meaning once you put that album out on Spotify, or once you put it out on iTunes, wherever you're putting your music out, once it's out there in those particular songs, not every song in your catalog, because I don't believe that that's necessary, but the things that you put out there for people to consume, that's what you want to register with the Copyright Office. And you want to go ahead and register them because after 5 years, the law or the court start to question your copyright certificate. So say you wait 5 years, and in year 6, after 6 years or 7 years of your song being out, you decide to copyright it. And then somebody samples your work. Well, the Copyright Office is going to say, okay, hey, yes, you have a copyright registration that in hand, but now we're going to question whether what you said in this copyright registration is valid because you waited so long to go ahead and register your work. So you want to go ahead and register that work quickly or as soon as you can, preferably before that 5-year period is over. So now when you present your copyright registration, that's not, it is not an issue. The copyright law and the courts go ahead and say, well, no, this registration, we're going to assume it's valid, and it's up to the person who infringed on you to then prove that your registration is not valid and not the other way around. So you want to go ahead and register your work within the first 5 years. And then finally, there's a court awarded compensation and legal fees that are allotted for you registering your copyright. You get what we call statutory fees, which is that $150,000 that everybody's always talking about, as well as legal fees and court fees that you can be awarded for somebody violating your copyrights. But once again, your songs have to be registered in order for you to be able to partake in those things that the law gives you, but you can't do it if your stuff is not registered. So you want to register your copyright. So in the event you're infringed upon, somebody samples your work, you have a copyright registration in hand and you are ready to file a lawsuit like today. Okay. Now, what is sampling? So we all have like a common definition of what we believe to be sampling, right? Or what we know it to be sampling. But I wanted to give us a formal definition so we can all work from this formal definition of sampling. So what is sampling? Sampling is the art of taking any sound from another person's work and making a digital copy, and then taking that digital copy and incorporating the copy into your own work, okay? So it's the creation based on somebody else's work. We've all heard, people's work being sampled, but it is really taking that digital copy and incorporating it into your own work. So you want to make sure that we have a working definition. So this is our working definition of what sampling is, okay? Now, moving on. So let's talk about sampling gone wrong. And I'm going to hit play. Let's hope this works, guys.
Thong song is going crazy. It's like killing the airwaves. And then, we get that call from our lawyer, like, have a seat. If you're standing up, you might want to take a seat. That's when all the drama started.
I get a call from Def Jam. And they're like, hey, we got a problem here. What's the problem? Well, there's a potential lawsuit from Ricky Martin because we stole the interpolation of Because You Live in La Vida Loca.
When he said that, I went back and I remember, I'm like, Cisco, man,
We gotta clear that.
Cisco had assured us, like, oh, I got a relationship with Desmond Child, who wrote Living La Vida Loca for Ricky Martin. We good. That's a phone call.
Here we go. Lawsuit.
And then the negotiations started. You know, we went back and forth for how much they thought they should get for the song.
And all of a sudden, like, you start seeing your publishing checks going.
Desmond Child has more ownership of the song than anyone. I'll just put it like that. And I'm sure Cisco didn't purposely say, you know what, no, I'm not going to clear that. But somewhere along the line, there was definitely an oversight.
As a manager, nobody came to me and said, can you get this clear? And then nobody at Def Jam, because you got to have your music go through all the licensing departments. So I guess nobody noticed it. I really couldn't tell you who's at fault.
We just got to take the L on this one. Like, we gotta pay them for that. So we paid them. So everybody that had something to do with it got their piece of the song.
All right. So this was a very, I'm sure many of you are aware, a very, very, very popular song. I believe like early 2000s, the thong song. It's like it was a summer anthem, right? Well, this is when sampling goes wrong because they committed or they broke the golden rule. And the golden rule, and we'll talk about this later, is that they did not get clearance for the song. So it wasn't even about, because as you can see, he basically admits, like, yes, I was inspired. Yes, you know, we've taken from that song, but somehow somebody dropped the ball and they did not get clearance for the song. And by failing to get clearance for the song, we end up in a situation where now they're having to pay out on the publishing side tons of money and of course share now in ownership of the song. So now let's just hypothetically say where there was a 50-50 split in publishing. I'm sure Desmond now on the backside of things owns 50% of the publishing by himself, and everyone else is only sharing in a small portion of it, if at all, because at that point, one of your biggest issues becomes once somebody is violated, now in order to make this go away, in order for us to settle, I want more than I may have probably asked for had you gotten permission. So you want to ask for permission versus forgiveness, because forgiveness is still going to cost you, but permission will allow everybody before, you know, the song blows up to be in their rational minds and to negotiate, in my opinion, in good faith, versus now when you have truly violated someone's copyright and infringed on them, you are at their mercy to make this go away because they have a legitimate copyright infringement lawsuit. So this is definitely sampling gone wrong. And I note here that failure to get permission, clearance by the necessary party saves you time, money, and the heartbreak of losing your publishing rights when your song becomes a hit record, because it only becomes a problem, honestly, when the song becomes a hit record. Most of the times we only hear sampling cases or sampling infringement cases on the biggest songs of the year, you know, your really big songs that everybody knows, and now all of a sudden, you know, you have this gray cloud over this hit song because there was a sampling issue. Somebody failed in this particular situation to get the sample clear, and that is one of the most important factors. You have to get a clearance and you have to get a license in order to sample. Unlike, let's say, for instance, your PRO, so everybody's familiar with ASCAP and BMI, where as long as your song is registered, they have the permission to give a license in order for you to get paid for your use of the song on the radio, for instance, right? Your publisher isn't directly handling that. But in the world of sampling, the only way to get permission is to contact the publisher, and you have to get that license directly from them in order for you to be able to use that song. Somebody failed to do that, and now one of their biggest songs, I'm sure for his particular career, the biggest song of his career, he has lost out on money because nobody got that sample clear. So this is just one of the examples of why it's so important to get your sample cleared, okay? All right, so next I want us to hop into factors. So everybody asks me all the time, well, how does the court determine if a sample if somebody actually sampled the work? Like, how do we know it's a violation? So let's go into some of the factors that the court considers when we start talking about a copyright violation or a sampling violation, okay? So these are factors, and I have a couple of slides here that'll talk about the factors that the court uses. And we'll also talk about some exceptions, okay? So first, we have striking similarities or substantial similarities. Now, when we say striking, as I've said here, striking is when two songs sound the same and the similarity can only be explained by copying. So essentially, it's like the exact song where there is no other way around it that you sample the song because it is legitimately the exact song. So that is one way to determine, okay, no, there's infringement here because there's no other way to explain how these songs end up being exactly the same. Well, in a lot of cases, striking is not our issue. What becomes the issue is substantial. Substantial because in substantial, as you see here, the songs are not identical, but they are close. And they're close because a lot of times producers or whomever will take bits of another song and translate it. They do that digital copy, but they translate it and they tweak it a little bit. So now it's not exactly the same. It's very rare that you're taking or that you see a copyright infringement lawsuit where they have literally just cut and paste basically. Typically you hear it where they've taken it and they've transformed it a little bit, but it's a sample, but they've transformed it a little bit. So the court does look at the substantial similarities in the two songs, and what they use is what we call the extrinsic and the intrinsic test. Now, those words are technical, but don't be alarmed. Essentially, it's the expert's ear versus the everyday person's ear. Now, our expert ear, it is the opinion of a musical expert. That is your extrinsic test. This person is a trained musicologist, and each of the parties, the plaintiff and the defendant, they are able to bring in their expert, and the expert sits down and explains to the jury why they believe, of course, that the song is actually very substantially used, the plaintiff, or the defendant brings in their expert, and that expert says, well, no, based on my education, training, and experience, I can tell you for sure, this song is not substantially similar to the prior to the plaintiff's song that they claim that we have sampled. Not the same at all. So you have the battle, what we call like the battle of the experts. What do the experts say about how this song is substantially similar or not? Okay, so outside of the experts, though, the court realizes like, okay, so where's the reasonable person? How does the reasonable person play into this? And the reasonable person plays into the intrinsic test. And in the intrinsic test, we talk about the everyday person's ear. What does the opinion of an everyday person, no musical training, maybe never even heard either of the songs, because typically that's what the attorneys are looking for. They're looking for people, especially if you're going to be if you're on the defense and you're trying to defend your copyright and say you didn't sample, you're looking for people who have no clue about either of these songs and maybe have never heard either one of them, because you want that person to tell you that they can hear a sample versus somebody who may have heard one song or the other, because it may, in a sense, make them biased, right? So this is the everyday person test. Can an everyday person say, oh yeah, I hear a little bit of that in this particular song? That does make sense, okay? So what does the everyday person say? So that is why you have a jury. And that particular test is really left at the hands of the jury and what the jury believes. So they may bring some witnesses, but really, in my opinion, that is truly where the jury plays a huge role in trying to determine if somebody has infringed or not, excuse me. Now, note, if you are having if it's a substantial similarity test, the experts and the intrinsic test have to be met. So you got to be able to meet both of those in order for there to be considered an infringement situation based on a sample. Next, what we have is unconscious copying. This is interesting because it is like a song that you haven't heard in God knows how long. We all know songs from years and years past, and we may not have heard it for 10 or 15 years, but as soon as that song comes on, you can repeat the lyrics verbatim, right? Well, this is called unconscious copying because that particular song, if you're working on something, you may be inspired by that song. So it's really the copying of a well-known song that occurs from your subconscious. You didn't have an intentionality to copy it because it wasn't in your face. You weren't literally taking that digital copy and placing it in there, but in a sense, because it is so ingrained in you, because of course we know the lyrics to this particular song, we know the groove of this song, we've been around this song is a part of our being in a sense. you have an unconscious copying that occurs. And so when unconscious copying occurs, the Copyright Office says, no, it's so ingrained, let's say even in culture, that you could have unconsciously copied it. And unfortunately, it's still copyright infringement, right? So I always find that one to be very interesting, because you can essentially infringe on someone's work unintentionally. So basically, it's the unintentional copyright or unintentional infringement in a sense, okay? So next, we have originality. Proof that you created the work and what you created had some degree of creativity. So for instance, you cannot claim copyright infringement if you quote a line from a Shakespeare play. Well, you took that from somebody else, so that's not infringement. Really, you use someone else's work. So that would not be considered or would not be a good case for copyright infringement. And they want to see some degree of creativity. They don't want what you're claiming that someone else infringed on you to be something that's so generic. And I use the example of there are 1,000 ways to say I love you, right? So if you want to claim that somebody stole your wording of I love you with all of my heart, well, that can essentially be commonplace, but what degree of creativity that can be found in tons of songs. So you want it to be something that is essentially truly creative to you, that's instinctive to you, that only you would have been able to say, that only you would have been able to create, not something that somebody could have found somewhere else. Because if that becomes a problem, then you don't meet the test of originality here, and you won't be able to claim that there's true copyright infringement. Okay. Now, we break it down and we go down now to also like prior works. Did the copying of the work come from something that existed before your work even existed? Another example here is genre. In every genre of music, there's a rhythmic pattern. There is something that is very unique to that particular genre that everybody in general uses. So it's not really protectable because it is truly a part of that genre where in order to even make this type of music, you end up kind of sort of having to use it. So in that way, this has already been here. This was work of art that was prior to you creating your work. And so the court doesn't wants you to be able to protect it, because the court doesn't want anybody to be able to protect it, okay? So with that being said, works of prior art cannot be protected. Okay. So next, I'm just keeping track of my time here, guys. All right, access. This is another biggie because in a lot of our copyright lawsuits, you hear about access and how did the person hear about your song in order for them to infringe. So you want to talk about access. The infringer had a way to hear the song and steal it. Access can be anything. It can be that the manager gave you the mixtape, and so that's how it got to you in order for you to hear it and then for you to infringe. A lot of times it is your bigger songs, you have access. It's automatically considered access, for instance, if it's a Billboard 100 song or a very, very popular song, because essentially they assume that in some form or fashion, whether it was in the mall, in a store, at a restaurant, or maybe your best friend sent it to you, that you had access to this very popular song in which now you have infringed upon. Now, back in the day, they used to say that if a song was found on the internet, like simply just posted on the internet, that was essentially access because it was the World Wide Web, right? Well, now because millions, and I would even dare I say billions of songs are posted to YouTube daily, they have really backed back on the belief that just because a song is on the internet, YouTube or wherever, that person had access in order for them to steal it. So now when you start talking about access, in addition to, just true person to person access where somebody gave you the track because it was an unreleased song, let's say, if you're talking about popular access, now you're having to say that the thief listened to that particular genre of music a lot. So say it's something that's unique. Let's say it's an EDM song or some, hip hop gospel. Let's use hip hop gospel, for example. They were very deep in the hip hop gospel. So that's really how they heard it, because that's not maybe a popular genre that everybody would listen to. Or it's located on a particular place on the web. Let's say, a really underground hip hop music website that not a lot of people visit, but this particular person is known to visit that site a lot. So that is how they got access to it. So you have to be more specific when you're talking about, oh, well, they got access because my song was on YouTube. No, you have to be more definitive of really defining what access looks like in order for you to claim or be able to say that they had access to the particular song, okay? So we have talked about our factors, but I also want to talk about our exceptions. One of the biggest exceptions that I always get, that I questions rather, that I always get is about minimal use. Well, if I only use like 10 seconds of it, can I use it and is it okay? Like, is that really infringement? So it's called by law de minimis, minimal taking of an infringed song. By minimally taking a portion of a person's song, it is not considered infringement, i.e. why it is an exception. And excuse me, I have spelled exception so wrong. But it is an exception. So with that being an exception, when you start talking about de minimis use, the law does not give us a hard and fast rule about what is considered minimum, right? It's not 10 seconds or 5 seconds or 20 seconds. It's not a time. They're not looking really at time. They're looking at the balance of, does the use go from minimal to substantial? And that line is honestly, guys, very, very, very thin, okay? So it is not minimal, it is substantial. And really, is it done to an unfair extent? Does it now cross the line of being cute to being like, you should pay me? And that's kind of what I equate it to. So how significant is the use? And if it's minimal, then yes, but there is no hard and fast rule. So when asked like, well, how much can I use without it being considered infringement, even though I know it's infringement? And that's really the key here. It's the acknowledgement that you're using the work, but what you're saying is, I'm only using a portion of it. Well, there is no hard and fast rule of what that portion looks like. So really, it's going to be on your own judgment of what is considered minimum. And let's be clear, of course, I may consider it minimum, or you may consider it minimum. And I may say, well, no, that's substantial use, or that's significant use, or you use too much. And now we're in a court trying to determine if it was minimum or if it was considered more than minimum, which then we enter into the waters of infringement. So it's going to be a gut call, but just know that varies per person. So as it varies per person, you want to stick with it being as little as possible so that you won't necessarily have that issue, because you kind of enter charting into the waters of that was more than a minimal use. So even though you acknowledge this infringement is more than minimal, so now you need to pay me, okay? So finally, we have an exception. The final exception is fair use. This is a more cut and dry exception. This exception has 4 factors, as you can see, and it is a use of a protected work without permission or having to pay them for a limited purpose, okay? Now, that limited purpose, the court realizes, is scholarship, teaching, newsworthy things, what else? Criticism, commentary. So when you say criticism, let's say it's a music blogger and they are reviewing your work. So in addition to their review, which they're telling, this is what I think, they may use some snippets of your music to explain to their audience what they're talking about. That would be considered like that form of criticism. Or commentary, I would say, is the news. Or, teaching, if your teacher uses some copyrighted material within the course of their lecture, that sort of stuff. Scholarship, research, in the quote of, let's say, somebody doing a deep dive of Nas's first album and making a book of it. Those sort of things considered scholarly or research. That is the fair use exception, where they may be using it, but they're using it for scholarship or research. So it is not considered, although infringement, the court and the law allows for them to fall under that exception now. When we start talking about the 4 factors, you want to evaluate them, and that is how essentially the court is going to evaluate it. So when thinking, okay, well, I feel like this is fair use, because there are several things that do fall under fair use. The 4 factors that the court considers is The character and the purpose of the work. Does it fall under what I talked about, those limited purposes? The nature of the work. How is the work going to be used? How much is the work used? Again, going back to our de minimis situation. The less amount of work that is used, the better off you are. By you can say like, oh, it was fair use or it was de minimis. The more you use, the less you start being able to use the excuse or the exception. Okay. And finally, and to me, this is one of your bigger ones. How does this affect the commercial use of that work? Does it give it negative press? Is it not used in a way? Is it used in a way that would harm that original work? Because if it is, then guess what? The court is going to say, not so much. Okay. So those are factors that I want you all to consider. Now let's get into our cases. Case study 1, blurred lines, a very infamous case. I've laid out our case here just so you all can get a broader view of what it looks like. But I wanted to also just kind of give you just the layout. So the timeline, as you can see, is when the song Gotta Give It Up was written, when it was copywritten, when Pharrell Williams and Robin Thicke actually wrote it. And it became in 2013 the best-selling single worldwide. After they tried to negotiate the copyright, the lawsuit failed, and essentially what happens is now we end up having, or the negotiations failed, and they end up having to file a lawsuit. So what happened? What happened was we had experts come in based on our extrinsic test that testified that there were substantial similarities. Then we decided what the juror's decision was. And we had access, going back to our access thing, because Robin Thicke or Pharrell Williams said, hey, I was inspired by this work, and that inspiration led to subconscious copying, and that's where we get caught up. So the court looks at all these things, and they start checking them off, and all of a sudden, we end up in a situation. So we end up in trial. Pharrell admits to that Marvin Gaye was inspiration. So that goes back to our inspiration access subconscious copying, because I don't think Pharrell actually literally did our digital copy from one song to the other. But that song, Marvin Gaye's song, was so popular, and he's saying he's inspired. He subconsciously in his bones knows that song. And he is so good at what he does, in my opinion, he ends up copying it without knowing he's really copying it, but it becomes copying. Okay. The court ruled that Pharrell Williams and Robin Thicke were guilty. T.I. was not found guilty because essentially T.I. was just a feature on the song. He really probably wasn't in the studio when they created and wrote most of the song. Okay. Marvin Gaye was awarded $4 million in damages and other things, and 50% of the ownership in publishing moving forward belong now to Marvin Gaye's family, which is a big thing. Now, what we learned is inspiration leads to unconscious copying, which leads to infringement if not careful. So that inspiration leading to subconscious copying, just knowing that, hey, if I'm inspired by something and I know it so in-depthly, you may want to consider just saying it's a sample and getting clearance so you can avoid what Marvin Thicke and Pharrell Williams went through. Now, the dissent in the case disagreed. They felt like the groove and the pattern of the song was a part of the genre, and that it was minimal copying and it wasn't actually true, substantial or similar copying. But clearly they didn't win because they still had to fail. And finally, our Nicki Minaj case. So Nicki Minaj versus Tracy Chapman. I would love this case, and I'm so upset that it did not actually go all the way to trial because, as you all can see, they actually settled. But these are the facts. In '88, Chapman wrote the song "Baby I Love You." In 2017, Minaj sampled the song in the song saying "I'm Sorry." In 2018, Minaj's sample request was denied. It was denied because Chapman is known for being on a do not sample list. It's an invisible list, but essentially people know she does not allow her songs to be sampled. So in 2018, when Minaj went to get that sample, she was like, yeah, no, not so much. But unfortunately, Nicki can't say no. She leaks the song, or not she. Somebody leaks the song online into a New York radio station. Nicki has text message exchanges with a particular radio DJ saying, hey, I want you to play this song. It's not going to make the album, but I still want you to play it. She claims that before she actually sent it, she decided like, oh, I'm going to change my mind. I'm not going to do it. So we end up in a situation of like, who done it? Who leaked the song? That was never ever revealed because we never really made it to trial on that point. But it became a whodunit because she said she didn't leak it, but the song did get out. Okay. So what was our infringement? Basic and willful infringement for putting the song out. There needed to be permission before creating the work. This is what the biggest thing here was. Should you have to now, as artists, get permission before you even attempt to sample and play with the song in the studio to actually even play with the song? Was fair use an exception? And then was it infringement because of the reproduction and distribution of the song on the radio to the New York radio station? Okay. Now the ruling said that fair use was granted. Fair use was granted because essentially the court looked at it like this, and it protected artists, and it was important for them to make this statement to the public that if you are in the experimental phase of actually trying to determine if you want to use this sample and you're playing with it and you're in the studio, you and the producer, it should not be a requirement that you get sample clearance permission in that experimental phase of this process. Now, if you decide to commercially release it, that's totally different. But the court protected the artist by allowing them to not have to get permission in that experimental phase, because that's essentially what Tracy Chapman was trying to say. No, before you even start playing with the music, you need to get permission. So the court knocked that down and essentially said, no, you are not required to get permission just to be in the studio and be playing with different samples because they want to promote the arts. You do have to get permission, though, moving forward if you're going to sample that person's song and officially release it for commercial release. Now, what we did not end up getting a ruling on is if just the leak, because remember the song was just leaked. It was never actually put on her album. If the song, just because it was leaked, is considered copyright infringement because of the reproduction and the distribution of the song on the internet and on the radio. We never got to that phase because, as you all can see, they settled the case for $450 million before we got there. But what we did learn was pre-clearance stifles innovation, and therefore artists are not required to get permission while the song is in production phase. So that was a great case, and I hope at some point we get another case that makes us really look at reproduction and distribution, and if a leak is considered like infringement or if it's just considered a leak, especially because Nicki never put it out on an album and she never had the intention to put it out on an album. But I guess time will tell. So guys, I think that is my time. Oh, I forgot proper sampling tips. So our final slide is proper sampling tips. So how to properly sample. First, you want to finish your song. No one is going to grant you permission without hearing a song first. That is the rule. Once you decide like this is it, you need to send the song over to whom? To the publisher. You want to locate and contact the copyright owners and identify who they are. Who owns the masters, who owns the publishing. They're going to want to hear that song before they give you clearance. Clearance comes with permission. You need to request a mechanical use license and a master use license from both parties. Now, if you do a replay, all you have to do is request the publisher's permission, because essentially you're replaying the musical composition and not the actual master recording. So it eliminates a person and eliminates that fee. Okay. So you want to first finish your song, locate and contact the owners of the song, get permission, and keep good accounting practices. If they're not going to give you the song on a flat fee where you don't have to account back to them, you want to keep good accounting practices, because the master owner may ask you to, basically for a percentage of royalties from the master recording. And then of course you have that publishing issue with mechanical royalties and having to pay out the publisher for those mechanical royalties. So you want to keep good accounting practices. But the basics of sampling is that permission is a must. That is the golden rule. Without permission, you cannot use a song. So if you don't get permission, avoid the courts and don't use a song. Okay. Now, I do believe that is my time. So this is my contact information. Feel free to hit me up if you have any questions or you'd like to schedule a consultation. I am here. But let's hop into the Q&A.